there's a major development you need to know about. A unanimous 9-0 Supreme Court decision involving the Fourth Amendment and the limits of police use of force. And now, the Fifth Circuit Court of Appeals has issued a new ruling in light of what the Supreme Court said, and things are getting complicated. Let's break down what's really happening here. Before we get started, make sure to subscribe to the channel if you want to stay updated on important legal cases like this that impact your rights. This story centers on a recent unanimous Supreme Court ruling in Barnes v. Felix. The case deals directly with the Fourth Amendment's protection against unreasonable searches and seizures, and specifically, when excessive force by law enforcement violates those rights. The court's decision in Barnes v. Felix is reshaping how courts across the country must analyze police use of force cases going forward. For many of us who pay close attention to law enforcement encounters with lawful gun owners, this ruling carries serious weight. We've seen far too many situations where simple traffic stops or misunderstandings turn deadly. The Supreme Court's analysis directly affects how those situations will now be judged under the law. But here's where it gets interesting. After the Supreme Court's unanimous decision, the Fifth Circuit reviewed the same case again. And despite what the Supreme Court clearly said, they once again ruled in favor of the police officer involved. They said his actions were protected under qualified immunity, applying what they called a totality of the circumstances approach. However, this case is now heading to the full Fifth Circuit en banc panel for another review, because of how the lower panel handled things after the Supreme Court sent it back. Now, let's go over the facts. Officer Roberto Felix Jr., a law enforcement officer in Texas, pulled over a man named Ashton Barnes for alleged toll violations that had been recorded by Houston freeway cameras. During the stop, Felix ordered Barnes to exit his vehicle. Barnes opened the door as if he was going to comply, but then suddenly tried to drive away. Acting in a split second, Officer Felix jumped onto the ledge of the moving car and fired 2 shots. Barnes was hit and fatally wounded within seconds, and the vehicle came to a stop shortly after. The entire incident, from the door opening to the fatal shots, took about 5 seconds in total. Following the shooting, Barnes's mother filed a lawsuit against Officer Felix, claiming he violated her son's Fourth Amendment rights by using excessive force. The district court, however, granted summary judgment in favor of the officer, applying what's known as the Fifth Circuit's moment of threat rule. That rule asks only one question. Was the officer in danger at the moment he used deadly force? Under that test, anything that happened before that specific moment is ignored. The Fifth Circuit Court of Appeals upheld that decision, agreeing with the lower court's application of the moment of threat rule. But when the case reached the Supreme Court, everything changed. The justices unanimously ruled in favor of Barnes, saying that excessive force claims must be analyzed under the Fourth Amendment's standard of objective reasonableness. This means courts must consider the totality of the circumstances, not just a single moment in isolation. The Supreme Court emphasized that a fair assessment requires careful attention to all the facts surrounding the incident, including what led up to the shooting. In short, the Supreme Court struck down the Fifth Circuit's narrow moment of threat test and told them to reevaluate the case correctly, using the totality of the circumstances standard. But when the case was sent back, the Fifth Circuit did something unexpected. Instead of holding new oral arguments or requesting new briefs in light of the Supreme Court's ruling, the 3-judge panel decided to rule again on its own, without hearing additional arguments. They concluded that even under the totality of the circumstances, the officer's actions were reasonable, arguing that any attempt to flee in a vehicle creates a deadly threat, justifying lethal force. This decision has sparked major backlash. Barnes's attorneys are now asking for the Fifth Circuit's full en banc panel to review the case again, arguing that the 3-judge panel's decision contradicts the Supreme Court's instructions. They say the Fifth Circuit effectively ignored what the highest court in the land had just ruled. Their petition also points out something especially concerning, that one of the judges, Judge Higginbotham, had previously written in a concurrence that if the totality of the circumstances test were applied, The officer's use of deadly force would likely be unconstitutional. But despite that earlier statement, when the case came back for review, he voted in favor of the officer again. This inconsistency has raised even more questions about the panel's reasoning. The petition further warns that the Fifth Circuit's new ruling effectively creates a dangerous per se rule, that police officers can shoot any fleeing driver, even when the initial stop was for something minor, like a toll violation. That directly conflicts with the Supreme Court's decision and with rulings from other federal circuits. Most other circuits require a fact-specific analysis, meaning that just because someone flees in a car, it doesn't automatically make deadly force reasonable. If left standing, the Fifth Circuit's ruling could set a precedent that makes it easier for officers to justify shootings during vehicle pursuits, even when the original offense was trivial. The petition argues that such a standard would encourage unnecessary use of deadly force in traffic stops, which could have devastating consequences. The attorneys are urging the full Fifth Circuit to either send the case back to the district court for a complete re-examination of the evidence, or to take up the case themselves and issue a new ruling consistent with the Supreme Court's instructions. What's even more surprising is the procedural shortcut the three-judge panel took, ruling without new hearings or evidence, right after the Supreme Court had explicitly sent the case back for further review. That kind of move is highly unusual, and it's expected to draw the en banc panel's attention. It could very well lead them to reverse the panel's decision or remand it again for proper analysis. So that's where things stand right now. We have a unanimous 9-0 Supreme Court decision clarifying how Fourth Amendment excessive force cases must be analyzed, and a lower appeals court that seems to have gone against it. All eyes are now on the Fifth Circuit's en banc panel to see how they respond and whether they'll correct course in line with what the Supreme Court has already said. As this case develops, we'll continue to follow it closely and bring you updates on what happens next. This is an important moment for how courts handle police use of force cases, and the outcome could shape law enforcement standards for years to come. If you found this breakdown helpful and want to support the channel, please like, comment, and subscribe. Your support helps us keep covering these major legal developments that affect your rights. Thanks for watching, and I'll see you in the next one.